Okay. I'm going to bring up the, so the bottom line, Supreme Court, we'll do this for a bit because there's some funny stuff. You can watch the MSM review and you can look at the commentators on both sides of the debate and you can know who's right, who's wrong, who's educated, who's ill-informed. You can know it just by the arguments that they raise. Okay, let's do this here.
Current New York law says anyone seeking a license to carry a gun outside their house must demonstrate, quote, proper cause to obtain one.
Proper cause is going to be the center point of the regulation that was at issue that led to this decision. The two individuals, this is an overview of the case, 30,000 foot overview. I do not know it in as much detail as Barnes or a great many other people. So take everything, this summary with a grain of salt, although I think I've got sufficient gist. Two individuals sought concealed carry permits under New York law. So the states in these cases all enacted state law, or the idea here is that some states enacted state law regulating concealed carry. The question was, is it unconstitutional in that it impedes on a Second Amendment federal constitutional right? Within the regulation, it said you can't get a concealed carry unless you show not probable cause, proper cause. Proper cause, which was not defined in the regulation, but read to mean, hold on, I just took the note, a unique need for self-defense. There were other proper causes like target shooting and whatever, but one of the proper causes to get a concealed carry permit in New York under that regulation, proper cause, which was unique need for self-defense. Okay. And then the question was whether or not this violates the Second Amendment, the 14th Amendment, and the Second Amendment. So fair protection, equal protection under the law, that being the Second Amendment constitutional right to self-defense. Okay, carrying on. If I can hit play.
Which state courts have said is a special need for self-protection.
I didn't even need to have my notes. Okay, and then listen to their first expert, and then you'll just see who do you think understands the issue and who presents the more compelling argument.
Question before the Supreme Court right now is whether New York can do that. Do you need to show that you have this risk to be able to have concealed carry, or can anyone on the R train now have a gun in their back pocket?
By the way, it's amazing now that I've read enough of the decision. Can anyone on the R train be carrying a concealed weapon? Well, there is an issue that, setting aside overturning this regulation, there can be reasonable limitations on where you can conceal carry, and on the subway might not be one of them. And it's funny, when I was in Virginia, and I just noticed it was at one of the museums in Harper's Ferry, had a sign that said, you cannot come in with a firearm, which means that you can carry one around elsewhere. So already, even within this expert, for anybody who knows, there's a bit of straw manning, because the issue does not become you can carry one wherever you want into a museum or wherever. The issue is proper cause. Is it sufficiently ambiguous? And does it impose an unfair burden on exercising a constitutional right? Court said, yes, it was an unconstitutional burden on the Second Amendment right to self-protection, an extension of the Heller decision from, I guess, more than a decade ago.
Challengers to the law argued the Second Amendment protects the right to carry firearms outside the home for self-defense, while supporters warn invalidating the restrictions could lead to more firearms on the streets.
This is an argument we hear all the time, and it was addressed by the court. I am fairly certain it was addressed by the court. The idea that, first of all, it will necessarily lead to more firearms on the streets.
Invalidating the restrictions could lead to more firearms on the streets.
It necessarily will, because it will allow law-abiding citizens to carry firearms on the streets. So it depends on what you mean by more firearms on the streets. Typically, colloquially, when we hear that, we understand that to mean criminals carrying criminal guns for criminal purposes. That's typically mean guns on the streets. You don't understand, or nor are you intended to understand, guns on the streets as including, for example, police officer guns. Police carry guns. You would not refer to that as more guns on the street. So They're clearly fudging, blending two ideas here. It will result in more guns on the streets, but not illegal guns on the streets, and not in the sense that everyone is concerned about more guns on the streets.
Supporters also maintain the Second Amendment was adopted to allow militias to fight the government, not allow everyday citizens to carry weapons for personal defense.
Okay. That was one of the arguments raised in the decision. It was only for militia. Hold on. I don't want to go to it. Was only for a well-regulated militia. I'm going to bring it up afterwards. We read the provision. A well-regulated militia and the right to bear arms shall not be infringed. That's the wording. So one of these arguments is because this only pertains to handguns, small arms, not rifles, not long arms. That the Second Amendment only refers to a well-regulated militia, which doesn't mean that individuals get to carry guns, concealed carry on the street. The court will throw that argument out and say, no, it's twofold, the Second Amendment, a well-regulated militia to fight government tyranny if need be, and the right to self-defense, the right to the preservation of the safety and security of your person. So they tossed that argument as well, and I think 6-3 decision, by the way, I think rightly so.
Question here is just a very narrow one. Can any state, not just New York, say, can you not have a gun when you're walking around town unless you're special? So the question is the default rule you can have the gun and you need to take it away only for someone with a mental illness, or is the default rule you can't have the gun and you could only have it if you have a special need for safety?
Even after the shootings.
That's sort of the question. Is it only for special people? Is self-defense only for special people? Is the right to bear arms, which shall not be infringed, only for special people to carry a firearm in public to protect themselves? Court says no. And the court says your proper cause, the unique, which has no definition, but it has been read to mean unique need for self-defense. Can you imagine being told you have no unique need for self-defense? It's only the people, it's only the special people, which is probably the people who already have enough means for their own hired security. The everyday citizen has no special need for self-defense. I mean, that's basically what it's saying.
In Buffalo, Texas, Tulsa, Philadelphia, and Chattanooga over the course of just a few weeks, the majority conservative court ruled anyone.
Oh, by the way, hold on. I cut this off. You got to hear this. This is some classic fake news spin.
If you have a special need for safety.
Even after the shootings in Buffalo, Texas, Tulsa, Philadelphia, and Chattanooga.
Even after the various shootings.
For the course of just a few weeks, the majority conservative court.
By the way, do you know what a non sequitur is? That's a non sequitur.
Ruled anyone can carry a gun anywhere.
It's a non sequitur and a bit of a straw man. It's a non sequitur because the premise has nothing to do with the conclusion. Even after a bunch of shootings throughout the country, the court came to the conclusion that people can carry a firearm for self-defense. I'm going to go out and venture. I don't know all of these cases. I don't know all of the cases she's referring to.
Even after the shootings in Buffalo, Texas, Tulsa, Philadelphia, and Chattanooga.
I'm going to go out on a limb and say those were probably illegal use of firearms. Probably illegal use of firearms. And some are going to go out and say, which could have been potentially averted had people been allowed to conceal carry. Let me just see which, because I think the first one was in Buffalo, New York, where this particular regulation prevented law-abiding citizens from having concealed carries, which would effectively prevent them from ever countering an unlawful use of a firearm. And I'm gonna go out on another limb. Probably the individuals who carried out these crimes probably did not apply for a permit, a concealed carry permit in the first place. If one is going to break the law, one is not going to apply for a permit to legally carry a firearm in public so they can then use it for criminal purposes. But it's so subtle. Even after a bunch of illegal acts involving people who used probably unlawfully procured firearms, but definitely use them for unlawful purposes, even after that, the court says individuals cannot lawfully procure, and use for self-defense firearms. It's not only a non sequitur, it probably actually, if properly explained, justifies the conclusion of the court.
Over the course of just a few weeks, the majority conservative court ruled anyone can carry a gun anywhere.
That's actually just factually incorrect. I think they said that the states could probably still enact regulations to restrict certain areas, so long as it's rational and a reasonable limitation. But
Constitutional attorney Andrew Lieb says New Yorkers should brace for a shift in expectations.
wait till you see this. But thus far, people, who's convinced by the expertise of that expert lawyer, Lieb? I'm not.
We've lived since 1911 with a law that said most people you're talking to don't have a gun on them. And now you're going to feel like most people you are talking to do have a gun on them. And that creates a different energy going on. Most of us in New York knew if we wanted to live in that environment, we could move to Texas.
But
Great point. Great point. I don't know what the crime stats are between New York and Texas, or New York City and Austin, but Austin might be a bad example because of certain policies. We could rest assured, hitherto, maître is what we say for lawyer in Quebec, Lieb Esquire. Hitherto, we could take for granted that when speaking with law-abiding citizens, we could take for granted, or at least in New York, when speaking with law-abiding citizens, we could take for granted that they are law-abiding citizens and therefore not breaking the law by concealed carry a firearm. We could take that for granted. We could not take for granted that when speaking with individuals who might be criminals, that they might not be respecting the law and might be concealed carrying, unlawfully so, firearms. Let's just follow the reasoning, Lieb. Hitherto, we could take for granted when talking to law-abiding citizens, they would not be breaking the law. Okay. Hitherto, under what will be the new regulation, we can take for granted that we might be talking to a law-abiding citizen who might lawfully be carrying a lawfully procured and lawfully carried concealed weapon. Am I to now think that this otherwise law-abiding citizen, who is now still respecting the law by having applied for, gotten the proper permit to abide by the law to conceal carry within the limits of the law, is now just going to pull it out and go crazy and just break the law? So yeah, when you're dealing with law-abiding citizens and you know they're law-abiding, you can count on them to abide by the law. If you feel I want that, you can go to Texas.
Attorney David Schwartz.
Okay, now here, take David Schwartz. Listen to his arguments and see who makes the more compelling argument.
Says the High Court's ruling simply allows regular people to carry a handgun in the state, not just the privileged few, celebrities, ex-cops, those with cash businesses as it is currently.
Someone who works late at night, that's leaving work late, it could be a nurse, it could be anybody that has to walk around late at night. They don't have a right now to get a carry permit.
Well, they have the right, but they have to show the unique need for, I'm just going to put my note up here, the unique need for self-defense. So maybe a nurse who's leaving a bad area at night might be able to make that argument. Maybe. But what was clear from the case, it was exceedingly difficult and capricious, arbitrary, where people were denied the permit, as the two petitioners, willy-nilly, relying on the better discretion of some bureaucrat. So a bit of a straw man, but the point is, now everyday people who feel the need, maybe because crime is going through the roof in a great many cities, feel the need, they can conceal carry, and some bureaucrat can't say, nah, you're not important enough, but Angelina Jolie is.
The idea that criminals now will go out and start applying for licenses, for carry permits, I think is a little bit illogical. It's going to be people that...
He's right. You cannot argue with logic. Criminals who were hitherto carrying guns to commit crimes or for criminal purposes, robbing a store, responding to a fight between clans. I don't know what the words I'm looking for. They're not going to now go apply for a permit so they can legally carry the gun, if concealed carry, so they can then use it for illegal purposes, because that only goes past the first incident of lawfully carrying it and then using it for criminal purposes. And I suspect there will probably be some restrictions in any event on who can lawfully carry a concealed weapon as relates to criminal history and the like. You can't argue with logic. It's just the way logic works.
Can't show an extraordinary purpose, but still want to carry a gun. And that really does fall within the heart of the Second Amendment.
Schwartz says the state will still be allowed to regulate where people can carry firearms and may exclude certain places like the subway system.
But we just heard the first guy say that every Tom, Dick, and Harry can now get on the subway pack and heat. And even if they could, I'm not so concerned about a law-abiding citizen who's lawfully applied for the permit carrying it for their own self-protection. Where it becomes a legitimate concern is if they, a citizen who lawfully procured the permit, concealed carry, if they drop it, if it discharges accidentally, if they're negligent in how they deal with it, if they forget it in the bathroom, like some Capitol Police officer. That's where, if there were stats to show that when you make it more accessible to the public to conceal carry for protection purposes, people just forget their guns willy-nilly everywhere and they just go off left, right, and center, shoot people in the legs, then you might have an argument. From what I understand of the decision, the dissenting opinions were not providing those statistics. They were providing suicide statistics. They were providing 100-year-old case law.
Ballparks and schools. The High Court struck down the New York law on the grounds it's too strict and gives too much discretion to state licensing officials.
Too strict and too much discretion is one way of saying vague and arbitrary. I mean, it's an amazing thing, by the way, because one makes it sound like there was logic to the system and they were just applying it strictly, whereas the reality was there was no logic. It was willy-nilly arbitrary and therefore purely capricious.
The ruling marks a disappointment to many New Yorkers who think federal gun regulation should be stronger, not weaker.
Well, this is mixing up an argument as well, because they're talking about federal gun regulations in the context of a state law that infringed on a constitutional right. So this is a problem when you don't understand the subject matter enough. But the citizenry, if you want stricter federal gun laws, then that's where you go to do it. I mean, but the issue is still going to be, can the feds, barring a constitutional amendment, infringe on a constitutional right?
The state of New York has made strides in reducing gun violence, and
this 2019 called "It Wants Its Statistics Back."
they continue to do so. We need the federal government to step up and to prioritize life-saving gun safety measures.
This person does not realize that she just made the compelling argument for striking down that state law that infringed on a constitutional right. If that is the argument, if you want the change, it's got to come from the federal level, and it's got to be by way of constitutional amendment in theory. Or there's, creative ways like eliminating liability for gun manufacturers so that they get bankrupted through lawsuits in highly politicized or political districts. That woman inadvertently made the argument justifying this court decision. It's not done through the state level firearm restrictions. It's not done at the state level. And if you want this change, constitutional amendment at the federal level.
New York State has no recourse on the SCOTUS ruling, barring a change in justices or a constitutional amendment.
Biden said it recently, is that you're not going to win the fight, I'm paraphrasing, on what the Second Amendment says. But what we can do is take away the liability protections on the federal level.
Here you go. If we can't get it directly, we're going to get it indirectly.
For the manufacturers. And even though then the government wouldn't be restricting people from having guns, the manufacturers, based on exposure concerns, would themselves restrict people from having guns.
Lieb pointed to the settlement reached in February that forced Remington to pay $73 million.
Yep. Oh, sorry, $73 million.
After the Sandy Hook massacre. Remington was the maker of the rifle used in that 2012 school shooting. The settlement bankrupted the gun manufacturer. In the newsroom, Jessica Moore.
So, I mean, it's actually fascinating because, and it shows you the game of politics. If you lose on the merits, try to do indirectly what the court basically said you can't do directly. And if this is where we're going, people, if this is where we're going, bankrupt the manufacturers of anything that, when used properly but for criminal purposes, causes damage, If someone poisons their husband, I don't know why I go straight to husband. If someone poisons their spouse with rat poison, bankrupt the rat poison manufacturers. Product designed for its intended use, did not malfunction, but was used for criminal purposes. Those are the three relevant points. Abstractify it from the tool, from the object. There is nothing uniquely. Someone's going to say, well, guns are only meant to destroy. False. Just false. Okay. They're meant for hunting. They're meant for self-defense, which I guess is a form of destruction. They're meant for target shooting. They're meant for a slew of other things other than illegal purposes. Vehicles. Not switchblades, because those are illegal in most places. Knives. Spyderco knives. Someone uses it for a stabbing. Why wouldn't the rationale be the exact same? It was made very sharp, so sharp it sliced right through the person. It was easy to open, so easy to open. The criminal opened it quickly, so sharp, cut through the person, and ended that person's life. Sue Spyderco, bankrupt Spyderco for the proper functioning of their object that was used for criminal purposes. Not as though someone's using a Spyderco knife and it's one of those lock blades and the lock blade doesn't work and it accidentally slices an artery and the person bleeds to death. Defective product leading to harm. Of course you sue the manufacturers. But the proper functioning of something that is used for illicit purposes, and now you want to open up the floodgates to bankrupting the companies for criminal use that people decide to make of their products. Let's see where that goes. It's not going to be anywhere good. I'm going to just pull up a few highlights from the decision. At least some important, some relevant parts. Let me just get, okay. So did I miss this super chat? I'm going to flag this, not flag, star. Sorry, I'm not flagging anything in any nefarious censorshiporial purpose. Where did I put the decision? Share screen. I think I got to go to tabs for this. Yeah, this is it. Okay, now I'm going to see in my notes. Are we looking at the same thing, people? How do I get rid of this? Yeah, whatever. I'm not going to be able to. I'm not going to waste too much time doing that. Just a few interesting passages. Let me make sure we're looking at the same thing. We are good. I had page 3. Well, we're going to do this. This might not be as fun as it was when I was doing it on my own. Page 3. To determine, let's see here, to determine whether a firearm regulation is consistent with the Second Amendment, Heller and McDonald point toward at least 2 relevant metrics. First, whether modern and historical regulations imposed a comparable burden on the right of armed self-defense, and second, whether that regulatory burden is comparably justified. Because individual self-defense is the central component of the Second Amendment right, these 2 merits are central considerations when engaging in an analogical inquiry. I loved at one point in the decision, I don't know if I can find it. Imagine someone said, when you're exercising your First Amendment rights, what's the word I'm looking for? You'd better have proper cause. You better have proper cause to be saying those words. And a necessity. You better have a necessity to say those words. The Second Amendment, it's an interesting thing, the argument that there's a hierarchy among the amendments and that the Second Amendment is almost as important as the First Amendment. But at the very least, it's exceedingly important. That's why it's the Second Amendment. Whether or not it's on par with the First Amendment, it's exceedingly important. A well-regulated militia, the right to bear arms shall not be infringed. I think I don't know, actually, I forget now whether or not the amendments, because of their order, are hierarchical. But just imagine someone said, you better have a proper cause to exercise your First Amendment. That would fly about as far as a Led Zeppelin. Does everybody know that that's actually the story of how Led Zeppelin got their name? They said they're gonna be as good. They're gonna be as successful in their band as the flight of a Led Zeppelin. You better have proper cause for speaking them words. It's not going to get very far. And some bureaucrat saying you better have proper cause to exercise your Second Amendment right to self-defense didn't go any further. Okay, so I'll pull that up in a second. Let's just get some super chats so I don't lose this. Nothing to add. Just want to say thanks for your channel and information you provided. Christopher Conard. That looked like canard, which is duck in French, but it's with an O, not an A. Thank you, and thank you all for allowing this channel to become what it is. I get to learn things in real time and have fun doing it, and make a living doing it. I love this stuff. I love learning in real time. I think I know so much more now about the Constitution, American law, Canadian law for that matter, than I did 4 years ago. I love doing it, and I'm glad people also enjoy watching it. Viva, please thank James on behalf of all of us peeps for his patriotism and endurance. I saw that one earlier and did. What would Bernhard Goetz go say? That's the guy who was on the subway in the 70s in New York, right? I think. Bernhard Goetz. Yes, it is. How does the dissent account for the fact that one of the shootings at the top of the list took place in Buffalo? The New York law at issue in this case obviously did not stop that perpetrator, Justice Alito. Not just that. It's not that the law didn't stop the perpetrator. It also prevented other people from stopping the perpetrator. The thing is this, bass player 2011 Iffy, that's an interesting name. It's not just that it didn't stop the person, it made it impossible for other people to stop the person. And it's not like, the thing is this also, anybody who's applying for a concealed carry permit, I suspect they're either going to, there's a risk. They're either going to be applying for this and not have any idea what goes into actually carrying a firearm in public. It means if you're carrying it, it means that something happens, you might be using it. It takes I don't know, not a special breed of person to do that, but it takes someone who's committed to that. From what I understand, in any event, the CCW permit process is relatively arduous and pretty hands-on. You learn. It's not a toy. If you're not ready to do this, you're not going to do it. So people who would have been concealed carry in that area presumably would be ready to use it if something happened. So it's not just that it didn't stop the act of criminality, it actually exacerbated it when it occurred. There's the old joke, an armed society is a polite society. There's exceptions to that, and it's not necessarily as simple as that. But I can tell you one thing, criminals might think twice. There is the argument that criminals might think twice, and it might make them even more aggressive in their criminal conduct. Or it might make them go look for softer targets, which might be why certain things tend to happen in certain soft, gun-free zones. Viva, you really need to get Tracy Wilson from the CCFR to talk about the handgun freeze in Canada. Screen grabbed, Andre. I'm going to see if I can find the person. Hitherto, criminals could take for granted the victim they confront would be unarmed. Yes, and sorry, I didn't mean to make fun. It's just when I see hitherto, I immediately break into Viva Golf voice. Hitherto. But yeah, it's whether or not it's going to make criminals more brazen, because if they have to assume that everybody around them is potentially armed, they'll be even more brazen in their criminality, or not. I mean, I'm not sure. You look at countries with the highest firearm homicide rates or the highest firearm gun violence. They tend to be places with high regulated, high degree of regulation. South America in particular. And then the counter argument is that, well, South America has high gun crime, not because of gun laws, but because of corruption. Criminality will find a way. California is following San Jose City ordinance requiring all gun owners to have civil liability for any use of their firearm, even if it was stolen and the thief committed the crime. Mark, so I'm not sure that I disagree with that so much. Liability for use, even if it was stolen. If it's stolen and reported, that would be the end of the liability. So where it would be an issue is if it's stolen and the individual does not report it. That's not unheard of. That's not. I would be shocked if a high court would say that's an undue burden on exercising your Second Amendment right. The argument might be that poor people might not be able to afford civil liability insurance. I'd have to flesh that argument out in my brain, actually, because I was going to compare it to driving and not being able to afford insurance, but driving is not a constitutional right. The right to bear arms is. If you make it financially, what's the word I'm looking for? Prohibitively expensive to carry the insurance that would be needed for civil liability, there'd be an argument there. But like, I fly a drone. Under Canadian drone laws, I had to have $1 million personal liability insurance in order to fly a drone lawfully. A drone that weighed 250 grams or more on takeoff. So there's something there, but I don't think that's egregiously shocking. That might make a little bit of sense. Most ASs have obtained guns with laws in place that would prevent them. Almost 95% has been a failure of the government to enforce current laws. Why trust them with more? Really now, we talked about it yesterday. Was it yesterday? The Nova Scotia shooting, worst one in Canadian history. They don't mention the fact, they're not too keen on mentioning the fact that that individual had procured his firearms unlawfully, illegally smuggled the small arms and unlawfully procured the long arms. They don't like to mention that. Even that they use as the pretext for more gun bans under the Order in Council. I don't know if all of them were unlawfully procured, but many of them were. But they don't like to mention that because that would mean that the existing laws they already have don't do anything or the existing laws are not being enforced properly. And by imposing even more laws, tell you what, the people who are never going to follow them in the first place still are not going to follow them. Hello from California or Canada? No, California. What does this mean for the timeline process for overturning cases decided by intermediate scrutiny? Example, Miller v. Bonta, Duncan v. Bonta. Okay, that's a question that I had. I went looking through that decision to see if they definitively addressed the intermediate scrutiny versus strict scrutiny versus rational basis. My understanding is that it's sort of affirmed was it intermediate scrutiny? I think it was intermediate scrutiny. Barnes and I are going to talk about this on Sunday, and Barnes will know. The man will know. And I know the limits of my own ability to read a 115-page decision in 2 hours, even to be able to talk about it. Rob from Law and Lumber said this morning, read the ruling, but substitute speech instead of gun. It makes it very clear. Absolutely. I mean, that was one of Thomas's points in the decision. Says the first and the second are the most important. And if it wouldn't fly for the first, it's not going to fly for the second. Can we apply the same logic to rushed? Really now, don't get me in trouble. Let me just read. Let's all read it together. But if you listen to Joe Biden, the gun manufacturers are the only company with immunity. And you know what? It's not even analogous. Because if the object, if the substance, if the product worked properly, you don't have to worry about a lawsuit. In one case, they want to go after the manufacturers for the proper but unlawful use of the properly functioning product. They want to allow people to go after them. In the other case, they immunize the manufacturer from the potential improper functioning or prejudicial or harmful functioning of the product. Immunize the potential negligence, incompetence, or worse on the one side, while what's the word when you make something about liability, while opening up the liability on the other side to a company that did nothing wrong but create a proper functioning object that was used for illegal purposes. This shows you where the priorities are at in the minds of the politicians. Intermediate scrutiny uses studies to amend the decision rather than what the lawmakers intended. I'm not sure if that's okay. So hold on, bring this back up here, and let's just see something here. I think we'll cheat. Hold on, let's see if I can get to one of the other pages that I knew was interesting. 15 and 19. The only problem is the pages start again on the other person's either concurring or dissenting opinion. There was something that I said on page 15 was interesting to read. Oh yeah, well that's the in sum. I won't highlight it. In sum, the Court of Appeal's second step is inconsistent with Heller's historical approach and its rejection of means and scrutiny. We reiterate the standard for applying the Second Amendment is as follows. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. Only then may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. Page 19 was another interesting one. Let's see what it was. Oh, well, they're going through Heller. That was it. It was forget it. We'll start here. We have already recognized in Heller at least one way in which the Second Amendment's historically fixed meaning applies to new circumstances. Funny thing, you're going to hear, I mean, Joe Biden said it. I think he got fact-checked. You couldn't own a cannon in 1776. Yes, you could. Yes, you could. And Barnes talked about it on the Duran, and we'll talk about it Sunday. You could own a cannon because protecting ships was an issue. You could own a cannon because it was necessary for self-defense. The question going to be, and the one that, the nuclear arms, chemical weapons, difference of scale. So here, just as the First Amendment protects us from just as the First Amendment protects modern forms of communication, and the Fourth Amendment applies to modern forms of speech, the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of its founding. Thus, even the Second Amendment's definition of arms is fixed according to its historical understanding. That general definition covers modern instruments that facilitate armed self-defense. See if intermediate is in here. There we go. We got. How many times do we have intermediate scrutiny? Hold on. Intermediate 20. Anyhow, that's it. I'll here. You can go read the decision yourselves if you want to. It's interesting. Interesting times, people. Did the Roe v. Wade overturn decision come down?